Thank you, everyone, for the testimony, and we'll move into the question and answer portion of today's hearing. And I now recognize myself for 5 minutes for questions. And Mr. Rosiak, we'll start with you. Today, the 8A program allows Washington insiders to sell government access and contract awards. What's your assessment of the program's current oversight mechanisms, and how effective have they been in preventing abuse?
So oversight hasn't worked, and it's not going to work. Set-asides are inherently extraordinarily vulnerable to corruption and fraud and waste. Wherever there's the prospect of millions of dollars going to somebody without the usual competitive process, the free market is going to find creative ways to get that money to where it would otherwise have gone, which unfortunately often means big companies. This waste is massive. If you look at, for example, the women-owned businesses in certain industries, say construction, asphalt paving, things like that, anecdotally, everybody that I talk to says the vast majority of these companies are actually owned by the husband of the woman that's the supposed owner. But realistically, how would the government ascertain who's really in control of the company? You'd almost have to, the government would practically have to be in the bedroom with them there to see who's exerting control over this business. It's not realistic. In cases of pass-throughs, the disadvantaged company is supposed to retain 51% of the proceeds. But it's virtually impossible to stop pass-throughs without having the sort of information that the government would realistically never see. There's so many ways around it. For example, if you partner with a non-disadvantaged company that's supposed to get 49% or less, you could put a lot of the expenses on the disadvantaged side, including maybe even taking some of the staff from the non-disadvantaged company and temporarily hiring them and putting them on the books of the disadvantaged company. It's trivial to hit that 51% marker. Not to mention that, in some cases, they may just keep 51% if they're too lazy to cook the books a bit. Just keep 51% as essentially, Senator Markey made a Godfather reference earlier. That's what I've heard some of these 8A, an 8A contractor himself likened himself to the mafia and said it's basically like the protection money or whatever you have to pay the mobsters. To get these contracts, the big companies kind of know they have an unspoken agreement with procurement officers and these 8A contractors that you got to cut them in on that. And I think that's not going to change. I don't see any way around that without basically just ending the practice of set-asides.
Wow. Thank you for that response. Mr. Hart, I want to go to something that you referenced in your testimony. You mentioned that your former boss, Senator Tom Coburn, someone that many of us respected so much, he worked with then Senator Barack Obama. One of these instances where we have people of different parties that are coming together to really do something good for our taxpayers. And what they did, they wrote the law creating usaspending.gov, and that's a searchable public website of government spending. My team spends a lot of time on that website. Was it their intent for other transaction agreements, or the OTAs, to be omitted from the website?
Absolutely not, Senator. That was never their intention. And as you've noted, that's a tremendous problem right now with USA spending. Mm-hmm. And that is one of the reforms that we need to do, is immediately fix and patch that so that money cannot be hidden from taxpayers. But we have to look at why did the founders write transparency into the Constitution? It's important to note they used the word shall in Article 1, Section 9, Clause 7. Mm-hmm. Shall provide a regular accounting of receipts. They didn't say you can provide that if you feel like it, if it's convenient for you and your political opponents, and will punish your enemies. They said shall. So it's a requirement, and that language precedes the Bill of Rights and the First Amendment itself. So transparency is a foundational first principle. Mm-hmm. It's the oxygen in the public square. We can't speak if we can't breathe. So if they wrote that today, I'm convinced they would demand real-time transparency be the norm. And our ambition 20 years ago wasn't just to pass a law, it was to create a norm and to create this assumption that, of course, government spending's online. Of course, we can search what government is doing. And so we need to, government always lags behind technology, so we need to move very quickly to upgrade our transparency laws today.
Yeah, I agree, because bottom line, if we don't know who is receiving taxpayer dollars and why, then there's no way for us to track that and hold recipients responsible for delivering what they've promised to our taxpayers. So I'm in complete agreement with that. My time is expiring, and I'll reserve the rest of my questions for another round. And with that, I will turn to Senator Hirono of Hawaii.